application of Imam against London Borough of Croydon.
Mr. Rutledge, is going to sit this morning from 10 o'clock until 1.
Yes.
And then again from 2 o'clock until 3 o'clock.
3 o'clock, my lord, yes.
This afternoon. We'll take a short break mid-morning about 11:30.
Thank you, my lord. Perhaps,
the time allocated to you is 10 until 1 and 2 until 2:15.
I read that as a maximum time, my lord.
You're not expected to continue between 1 and 2 o'clock.
Lord, yes, I understand that. I'm grateful. Perhaps my learned friend Mr. Calzavara will remind me at 11:30 where to break. May it please the court, I appear with Ricardo Calzavara for Croydon, Martin Westgate, King's Counsel, and Sarah Steinhardt represents Miss Imam. Lord, before I start, there are two short administrative matters. Yes. The first is that Croydon needs permission pursuant to PD 6.3.12 to rely on its supplementary case. That case was put in to respond to Ms. Imam's additional grounds for upholding the decision of the Court of Appeal, and there's no opposition from Ms. Imam to the permission being granted, and I'd be grateful if we could rely on that in the course of argument.
Yes, very well.
I'm much obliged. The second matter is that the parties have lodged an agreed note setting out the position, at least so far as the pleadings are concerned, about whether issues were taken in the courts below. If we may have permission to refer to that in the course of argument, and indeed during the course of this hearing, we'll see if we can come to a much fuller agreement to assist the court on that.
Yes, the note is very helpful. Thank you. We certainly have permission to rely on it.
Thank you. Much obliged. Lord, by way of roadmap, the submission will be in 5 parts as follows. Firstly, legislative and policy framework. Second, the relevance of resources to the performance of the main housing duty. Thirdly, submissions on ground 1 of the appeal. Fourthly, submissions on ground 2 of the appeal. And fifthly, concluding remarks and disposal. Lord, can I then begin with the legislative and policy framework? The main statutory provisions that we will be concerned with on this appeal are contained in the Housing Act 1985, Part 2, that's the provision of housing accommodation, and Part 4, secure tenancies, and the Housing Act 1996, Part 6, allocation of housing accommodation, and Part 7, homelessness. But we will also be inviting the court to consider some previous legislation, and in particular the Housing and Homeless Persons Act 1977. The current statutory framework is set out by the Deputy Judge at paras 24 to 34. I needn't take the court to it now. That's at page 282 in the key documents bundle, and in paragraphs 5 to 19 of Lord Justice Lewis's judgment to Court of Appeal. That's at page 226. And I will bear in mind that the court has those.
David can't open his electronic file, so I think we may need just a pause for a
Right. We have a technical problem with opening the electronic file, and we're going to rise for a moment so that can be sorted out, and then hopefully we'll have a free run at that point.
Yes, of course, Bernard.
Mr. Rutledge.
Thank you, my lord. Can I begin with the Housing Act 1985, Part 2, at page 576? This is concerned with the provision of housing accommodation, And what this part does, my lords, is to, it deals with how local housing authorities acquire accommodation, what they do with it, and how they may dispose of it. If we look at the acquisition powers first, that's section 9 and section 17. 9 is at page 579, entitled Provision of Housing Accommodation. And Lords will see that it sets out very broad powers in the local housing authority to buy, build, convert, and so on accommodation. Section 17 at page 591 gives them powers of acquisition of land for housing purposes. Section 18, page 592, tells local authorities what they must do with the accommodation once they have acquired it, and that's to put it into an order that it can be used as housing accommodation. And at the end of the paragraph, the section, they shall, as soon as practicable after acquisition, or as the case may be after completion of the necessary works, secure that the house or building is used for housing accommodation. Now, Lords, just note, please, at page 596, that section 22 is entitled Allocation of Housing. That was repealed when Part 6 of the Housing Act 1996 came into force, as I shall explain in due course. But finally, in relation to Part 2 of the 1985 Act, can we go please to page 624?
6.
And this sets out in section 32, page 624, the power of the local authority to dispose of land. And relevant for the purposes of this case, we see that the powers of disposal, other than for the right to buy, subsection 1, or with the consent of the Secretary of State, section 2, subsection 2, subsection 3, no consent is required for the letting of land under a secure tenancy or an introductory tenancy, or under what would be a secure tenancy, but for paragraphs 2 to 12 of Schedule 1. Firstly, an introductory tenancy is a probationary secure tenancy, but the relevance here is that included within those paragraphs 2 to 12 of Schedule 1, as we'll see, is the provision for a non-secure tenancy. And I'll come back to that and the relevance of that in due course. Can we then go, please, to the Housing Act 1996, the relevant act for the purposes of this appeal, which begins at page 681. I'm sorry, before we get to that, forgive me, can we just note, please, that 679, two provisions here in Part 4 of the 1985 Act. We're still in the 1985 Act, but this is Part 4, which deals with secure tenancies. 79, Section 79 at page 679, defines a secure tenancy and makes it subject to the exceptions in Schedule 1, tenancies which are not secure. And then at page 680, we have Schedule 1, Paragraph 4, a tenancy granted in pursuance of any function under Part 7 of the Housing Act 1996, homelessness, is not a secure tenancy unless the local housing authority concerned have notified the tenant that the tenancy is to be regarded as a secure tenancy. So generally, tenancies granted to homeless persons under Part 7 are non-secure, but the local authority has the power to make them secure. That is all for present purposes in relation to the 1985 Act. Can we then move, please, to the Housing Act 1996, which begins at page 681. And first of all, Part 6 of that Act, which is the allocation of housing accommodation. And this is largely power-giving, Part 6, but it contains some important duties. Section 159, which is at page 682, defines an allocation, and it includes the selecting a person to be a secure or introductory tenant. But can we please note 159 subsection 3, that the reference to selecting a person to be a secure tenant includes deciding to exercise any power of an existing tenant or licensee that his tenancy is to be secure. So if there's a non-secure tenancy under Schedule 1, Paragraph 4 of the 1985 Act, and the local authority notify that tenant that their tenancy is going to be secure, that constitutes an allocation. And then at the end of section 159, subsection 7, subject to the provisions of this part, a local authority may allocate housing accommodation in such manner as they consider appropriate. And then an important provision in Part 6 is section 166 capital A, which appears at page 695. Contrary to the numbering, this is an original paragraph. The numbering of this part is slightly unusual because of the number of amendments. But this is entitled Allocation in accordance with the allocation scheme. Subsection 1, every local housing authority in England must have a scheme for determining priorities and as to the procedure to be followed in allocating housing accommodation. And then subsection 3 is important. As regards priorities, the scheme shall, duty, subject to subsection 4, be framed so as to secure that reasonable preference is given. And then 5 groups are set out. And Lords will see that the second group is persons who are owed a duty by any local housing authority under the relevant provisions in the Housing Act 1985, in relation to the homelessness provisions in this Act. So the statutory homeless are given a reasonable preference amongst others defined in that group. And then subsection 3 goes on. These are largely amendments introduced by the Localism Act to enable local authorities to give additional preference to certain groups. There's a power, except for those serving in the regular armed forces or formerly serving, in which case there's a duty to give additional preference, and that's pursuant to the Armed Forces Covenant. So the scheme is that a local authority must have an allocation scheme, regardless of whether it has any housing stock. It must have a scheme. That scheme must give reasonable preference to those listed groups A to E of subsection 3. Amongst those groups, the scheme may, or in the case of the Armed Forces Covenant, must give additional preference. And then finally, subsection 14 at page 697, a local authority in England shall not allocate housing accommodation except in accordance with their allocation scheme. Lord, I've mentioned the reasonable preference group. They actually go back almost 100 years to the Housing Financial Provisions Act 1924. But for present purposes, without going through all the statutes, can I simply invite the court to consider at page 498, because it's relevant to the submission in due course, 498. Is the Housing Act 1957, Part 5, and Section 113. And this sets out in subsection 2 the then reasonable preference groups. And I will show how that group was added to when the 1977 Homelessness Act came in to include the statutory homeless. We've set out in our case the fuller position in relation to reasonable preference, and I needn't take the court to it now. Can I go then, therefore, to the homelessness provisions, Part 7 of the 1996 Act, starting at page 710. My Lords, the scheme of this legislation is well known. It's set out in the judgments, and I'll take it as quickly as I can. Can I emphasise that the court has been provided here with the version of Part 7 which predates the implementation of the Homelessness Reduction Act 2017, which came in on the 3rd of April 2018, as that is the version applicable to this case, as Lord Justice Lewis accepted at paragraph 6 of his judgment. But because this case is about the main housing duty, we've provided the court with the current version at 783. Part 7, my Lords, consists largely of qualifying criteria and duties, and essentially the level of the duty is determined by how those criteria apply to them, and the highest duty that is owed under Part 7 is under Section 193, subsection 2, and that's generally known as the full or main housing duty, and I shall be referring to that in this appeal as the main housing duty. Can I just invite the court to look at one or two provisions before we get to that point? Firstly, Section 175 at page 710. This is the definition of homelessness. It's been said before that this section effectively creates three categories of homeless. The first category in subsections 1 and 2 are those who have no accommodation of any kind, the street homeless, rough sleepers and the like. The second class, represented by subsection 3, are those who have accommodation, but for one reason or another it's not reasonable for them to continue to occupy it. And the third section is dealt with in subsection 4, those who have accommodation which is reasonable to occupy, but they're threatened with losing it. And at page 712, my Lords, is section 177. This was, as we will see in due course, an amendment to the original Act. It came in after the Pulhofer decision, and it deals with whether it is reasonable to continue to occupy accommodation. And importantly for this case, subsection 2 says in determining whether it would be or would have been reasonable for a person to continue to occupy accommodation, regard may be had to the general circumstances prevailing in relation to housing in the district of the local housing authority to whom he has applied for accommodation or for assistance in obtaining accommodation. And then there's power in the Secretary of State to prescribe other circumstances where it may be deemed unreasonable for a person to continue to occupy. And then we have other provisions. Priority need is well known. That's section 189, page 727. Eligibility, the benefits are only, or the services are only provided to certain persons from abroad, or rather certain persons from abroad are excluded. 730 is intentional homelessness. And then we come to the main duty itself, which is at 732. Subsection 1 tells us when that duty arises, where a local housing authority is satisfied that an applicant is homeless, eligible for assistance and has a priority need, and are not satisfied that he became homeless intentionally. Subsection 2 is the important provision so far as this appeal is concerned, unless the authority refer the applicant to another local housing authority, see section 198, pausing there, that's on grounds of local connection. Continuing. they shall secure that accommodation is available for occupation by the applicant. And then subsection 3 tells us when the duty ceases. The duty, subject to the duty under this section until it ceases by virtue of any of the following provisions of this section. And then my lords will see that the section sets out a number of different circumstances in which the duty will come to an end. And it gives the local authority a range of options in terms of securing accommodation. They can, for example, under subsection 5, provide a tenancy which is not Part 6 tenancy or not a private rented sector offer, PRSO. Under subsection 6, they can discharge duty by making a Part 6 offer. So that's 6C and 6CC by making an arrangement by which the applicant receives an assured tenancy with a private landlord. And then subsection 7AA is the PRSO provision. So there are a number of options there. Okay. And then, my lord, section 205, 764. We have a number of provisions concerning discharge of functions, and importantly, it's section 206, which is at page 765. This tells the local authority how it may go about discharging its duty, the main housing duty under 193. A local authority may discharge their functions under this part only in the following ways: by securing that suitable accommodation is provided by them is available, by securing that he obtains suitable accommodation from some other person, or by giving him advice and assistance as will secure that suitable accommodation is available from some other person. That's where suitability comes in to the duty to the main housing duty. And then section 208 at page 766 concerns out-of-area placements. So far as reasonably practicable, a local housing authority shall, in discharging their duty, secure that accommodation is available for the occupant of the applicant in their district. And then section 210 at page 768 deals with suitability of accommodation, requires the local authority to have regard to a number of statutory provisions, including slum clearance, overcrowding, and the Housing Act 1984 health and safety measures. And it also gives the Secretary of State power by order to specify circumstances in which accommodation is not to be treated as suitable, and those provisions are at pages, I needn't take the court to them now, but they're at pages, or those orders, 2 orders have been made, pages 800 and 806. If I may, I'll come back to those in due course. And then section 202, page 755. This was an innovation of the 1996 Act, and that is a statutory right to a review of a range of...
I'm so sorry, I missed the page.
Sorry, page 755. I'm sorry, my lord. 755, section 202. Gives a right to request the review of a range of decisions, including the suitability of accommodation. That was brought in by the 1996 Act, and that is coupled with a provision, a well-known provision at section 204, page 760, of a statutory right without permission to the county court on a point of law. And finally, for this Act, can we please note Section 182 at page 717. And this is a provision for the Secretary of State to publish guidance to which the local authorities shall have regard in the exercise of their functions. And we have chapters from that guidance in the bundle, and I shall be inviting the court to look at those in due course. Lord, those are the statutory provisions. Can I turn very briefly to the policy framework? And I can make it brief because helpfully the Deputy Judge set these out. There are two policies in the key the key documents bundle. I'm so sorry, the appeal documents bundle, page 320. The Lord should have a copy of the housing allocation scheme in the London Borough of Croydon. This is the scheme that complies with Part 6, and it sets out the priorities and so on. It's a choice-based banded scheme with provision for direct offers. Can I just invite the court to look at very quickly at two parts of it? Page 321. Sorry, page 385. I'm sorry, I've misread my note. 385. The provision for direct offers and paragraph 356. This is page 385 and it's para 356 of the policy. Direct offers of housing adapted for disabled people. Vacancies which are adapted or which are suitable for adaptation for applicants with a substantial disability may be offered directly to the most appropriate applicant. Whether housing has significant adaptations or is wheelchair accessible, this will be on suitability alone and outside any strict date order. For homes which are not adapted or have limited adaptations, there may be several applicants who could fit the vacancy, and we will allocate in band and then date order. 329, is it? Yes, I'm sorry, I'm grateful to my friend. The page I was struggling to find was at page 329, and it just sets out band 1 priority, urgent, and invite the court just to note that. This is the highest band of people on the housing register in Croydon, and the circumstances which enable them to qualify for that priority. And it's a very serious band, as one can imagine, severe medical or disability problems, and so on and so forth. Thank you. And then Croydon also has a Part 7 accommodation allocation policy, which is at page 415. Again, the Deputy Judge helpfully refers to this, and can I invite the court to look, please, at paragraph 4.1 at page 417, page paragraph 4.1. And essentially, due to the high level of homelessness demand within Croydon, homeless households are usually accommodated through a two-stage process. Nightly let accommodation, then move to longer-term TA, supplied through a variety of providers. And then over the page at 418, 4.3.5, some temporary accommodation is specialist. For example, those with physical disabilities or mental health needs, the units will only be offered to those who meet the criteria for this type of accommodation. So that's the Parts 2 scheme. And all that completes the first part of my submissions on the legislative background and the policy. Can I proceed, therefore, to part 2 of the submission, which is pretty much the heart of the appeal. It's the relevance of resources to the performance of the main housing duty. And Lords, if I may, I propose to deal with it in 2 parts. Firstly, as a matter of principle, in principle, are resources relevant to the court's remedial discretion in a case concerning a breach of the main housing duty? I'm limiting my submissions to that duty. The main housing duty is applicable in this case. And secondly, did the Deputy Judge fall into error in this case? And this represents agreed issues 2, B and C of the Statement of Facts and Issues. Can I begin, therefore, with the question in principle? And Croydon's headline submission is that whether a statutory duty permits consideration of resources in its performance is ultimately a question of interpretation of the duty itself and the context in which it arises. And we derive support from that to a case I'll take the court to in due course. It's G and Barnett per Lord Nichols at para 13 and Lord Scott at para 133. I'll come back to that case. So ultimately we say it's a question of interpreting the duty in question. On this, Lords, Croydon makes 4 points. I'll highlight them first and then develop them if I may. The first is that subject to limited exceptions, one of them being whether a person has a priority need, whether they have a medical condition, for example. Subject to limited exceptions, resources run throughout Part 7, including the performance of the main housing duty. And on that, I invite this court to look at earlier decisions of this court in Nazella Meso and Pochte. I'll be taking my lords to those cases to make good that submission. Resources run throughout the whole of Part 7. That's the first headline submission. The second is that the main housing duty, although it's immediate, non-deferrable, and it confers a personal right in the applicant, it's nonetheless an unusual duty, and it's one that has to be performed both for the benefit of the individual to whom it's owed and for the wider social purpose saved by the legislation. That's a submission, and to seek to make good that, I should be inviting the court to look at the Housing Homeless Persons Act 1977 and the decisions of the House of Lords in Din, Pulhofer, O'Rourke and Runa Begum. And
Sorry, the last one was
Runa Begum against the London Borough of Tower Hamlets.
Thank you.
And also, in our respectful submission, an illuminating judgment from Lord Justice Lewison in the Court of Appeal in a case called Ali Gabet. That's the second submission. The third submission we make on this is that the availability of suitable accommodation, whether it's available, is already an established consideration for the exercise of remedial discretion in relation to the main housing duty. And on that submission, we will be seeking to draw support from 2 decisions of the Court of Appeal. The first in the case called Cadona, and the second case of Slattery, a judgment of Lord Justice Briggs as he was. So that's our third submission. And our fourth submission, responding to the way that both Ms Imam and Crisis have put their case, is that Section 193 itself cannot be interpreted as excluding considerations of resources. On the contrary, we say. So, Lord, those are the headline submissions, and I now seek to make them good in that order. Can I begin with the first one and remind the Lords that it's subject to limited exceptions, resources run throughout Part 7, including the performance of the main housing duty. Can I invite the court to look at 2 previous decisions of this court on that? The first is the case of Nazella Meso and Westminster, which is at page 1064, 1064. My Lord, because I'm using hard copy, I'm slower than my Lord, so I apologise for that. Nazella Meso is a well-known case. This concerned the main housing duty and out-of-borough placements. This was the case where Westminster placed applicants in Milton Keynes, and this court held that that was an unlawful placement, amongst other things, because it failed to have proper regard to statutory guidance issued by the Secretary of State, which is often referred to as the concentric circle guidance, where the local authority, rather than place somebody a long way out of borough, must first see to whether they can source accommodation closer to. But the Nazella Meso case, I emphasise, was a case on out-of-borough placement, and my Lords will recall that I took the court to section 208, which says so far as reasonably practicable, the local authority shall accommodate in borough. So I accept that there is an element of discretion there. But can I just invite the court to look at the leading judgment of Lady Hale? She, at paragraph 1, sets the issue, when is it lawful for local authority, sorry, page 1066, para 1, when is it lawful for local housing authority to accommodate a homeless person a long way away from the authority's own area? And then at paragraph 13, at page 1069, Her Ladyship sets out the wording of section 208 that I've already read to the court. And then helpfully, at paragraph 38, page 1076, Her Ladyship provides guidance to local authorities in case of this type. And when we look at the Akipiet case in the Court of Appeal, we'll see that the local authority...
Forgive me, paragraph
38.
At 10?
1076.
Thank you.
I'm sorry.
My fault.
This is Lady Hale at the end of her judgment providing guidance to local authorities how they should approach out-of-area placements. And at 38 she says, but how, it may be asked, are local authorities to go about explaining their decisions? It is common ground that they are entitled to take account of the resources available to them, the difficulties of procuring sufficient units for temporary accommodation at affordable prices in their area, and the practicalities of procuring accommodation in nearby authorities. So there's a reference there to resources. And I'll come back to that, or I'll refer back to that when we look at Poshte. But before we leave Nazella Meso, can I invite my Lords to look at paragraph 41 at page 1077? After explaining the type of policies that local authorities ought to adopt, Her Ladyship said, indeed, it would also enable a general challenge to those policies to be brought by way of judicial review. In some ways, this might be preferable to a challenge by way of an individual appeal to a county court. Again, I'll come back to that. That was the first case. Can I go then to Poshte and the Royal Borough of Kensington, Chelsea, which is at page 1121. This, too, was a main housing duty case. The issue was suitability of accommodation, but the question in this case, the third time of asking, was whether the main housing duty constituted a civil right for the purposes of Article 6 of the Human Rights Convention. I say the third time of asking because the first time that issue came before the higher appellate courts was the case of Runeberg and the London Borough of Tower Hamlets, a case that my Lord Sales would be particularly familiar with. The court on that occasion found it unnecessary to decide the issue and proceeded on the assumption it did engage. Then it came to this court in a case called Alley and Birmingham, which decided that it did not engage, it was not a civil right, didn't engage the convention. The court at Strasbourg took a different view, which meant it came back to this court in Poshte to consider again. And this court in Poshte, the judgment given by Lord Carnworth, with whom the other members agreed. If we could just pick it up at a head note, which is at page 1122. It's the first finding. In accordance with previous fully considered and unanimous decision of the Supreme Court, that's the Ali case, the conferring of a benefit dependent upon the exercise of an evaluative judgment by a public body, including the right to accommodation under Section 193, was not a civil right for the purposes of Article 6 of the Convention, in part because it was not in the public interest for funds allocated to social welfare schemes to be unduly consumed in administration and legal disputes. Can I just invite the court to note some passages in Lord Carnworth's judgment? If we go, please, to page 1136, at para 20, his lordship discusses the domestic authorities, and there's reference there to this court's decision in Alley and Birmingham about a distinction being drawn between the class of social security and welfare benefit whose substance was defined precisely and which could therefore amount to an individual right, and those benefits which were in their essence dependent upon the exercise of judgment by the relevant authorities. That cases in the latter category, where the award of services or benefit of kind dependent upon a series of evaluative judgments and how the applicant's needs ought to be met, did not amount to a civil right. That was the decision in Ali. Then at his lordship continued, the right to accommodation under Section 193 was held to fall within the latter category and therefore outside the scope of Article 6. And then at paragraph 27, page 1138, Lord Carnworth refers to Nazella Messo and the passage that I've just taken the court to in the judgment of Lady Hale. And 5 lines from the bottom says, however, the court recognised the pressure facing authorities dealing with such cases and the range of considerations which needed to be available of accommodation in their own areas, including the resources available to them. So there's a reference there to resources. And then finally, at para 35, where Lord Carnworth reaches his conclusion, a few lines from the bottom, it is hard to see, this is page 1142, para 35, it is hard to see any fair comparison with the range of factors, including allocation of scarce resources, to which authorities are entitled to have regard in fulfilling their obligations under the housing legislation. In fairness to the Chamber, it may be that it's spelled out in the government's submissions, and so on. So what that case decided, it affirmed the earlier decision of this court in Ali that the main housing duty does not constitute a civil right for the reasons given in Ali. And relevant to that, I mean, I don't think I can go so far as to say it's within the ratio, but it's close to it. Relevant to that is the fact that resources are relevant as part of the evaluative exercise that the local authority has to take into account. So we say that those two important decisions of this court do support the proposition that resources we make that resources run through Part 7 with the limited exceptions, including the performance of the main housing duty. Well, that's our first point. Can I proceed then to the second point, which concerns the nature of
What's the relevance of that to this appeal? Because it's accepted that the duty has arisen, so one's come through the process of taking account of resources and so on in order to conclude that the main housing duty is applicable and has been breached.
My Lord, the submission is that resources are relevant to the way it performs its duty. That's the submission I'm building. It's not just whether the duty exists, but how the local authority performs its duty once it exists. That, when I come to my fourth point about the construction of the section, that will be clear, and perhaps the second point might.
But why is how the duty is performed relevant here? I thought it was accepted that there's been a breach of the duty.
Yes, of course.
So we're into the question of remedial discretion, which is a matter of general principles, what one might think, applied by the courts rather than the matter of statutory construction.
Because, I'm sorry, Lord.
No, well,
because the focus of this case is on the steps the relevant steps, the local or reasonable steps the local authority take in the performance of their duty. What's being said here is that the local authority has failed to perform its duty because it hasn't taken all reasonable steps. Our submission is that the steps the local authority take are steps which are informed or at least can have regard to resources.
I thought that you accepted that there'd been a breach of the duty.
Yes, there is a breach of the duty in the sense that the duty arose and they haven't secured suitable accommodation. That's the breach. But we say in performing, it's an ongoing duty, so it's an extant duty, an unfulfilled duty, and in seeking to perform that duty, the local authority takes steps. And we say, respectfully, the question is, are they allowed to take into account resources in performing those steps? Do resources come into it? Lord, hopefully that will become clear as I build the submission. Can I go on to the second proposition, which is that the main housing duty is an unusual duty in that it is performed both for the benefit of the individual and for the wider social purpose served by the legislation. And on this, can I begin by inviting my lords to look at the Housing Homeless Persons Act 1977, which is at page 529. My lord, we set out in our case the background to this legislation. I don't think I need to take the court to it now. But essentially, the first modern-day provision for the homeless was contained in the National Assistance Act 1948, section 21(1)(b), and that vested in welfare authorities related to be assigned to local social services authorities a duty. So before 1977, the responsibility for the homeless lay with local social services authorities. And in 1974, the Departments of the Environment, Health and Social Security in the Welsh Office began what they described as a campaign to move responsibility from social services to housing authorities, and we've put that circular in the bundle at page 1766. Now, that move from social services to housing was achieved upon the passing of this Act of 1977. And if we could just see what that did technically, if we go to page 543. This is the schedule to the 1977 Act, and we can see that it repealed section 21(1)(b) of the National Assistance Act. So that affected the shift in responsibility. And also in section 6, subsection 2, the page 533, it made an amendment to the Housing Act 1957, section 113, the reasonable preference groups, to include those owed duties under this legislation. So homelessness functions shifted from local social services authorities to local housing authorities, and those owed duties under the new homelessness legislation were given a reasonable preference with others under the 1957 Act. Can I invite the court to look at some of the features of the 1977 Act at page 542. Or to see the Act came into force in England and Wales. This is section 21. It came into force in England and Wales.
Could you just give me that page number again, please?
542.
Thanks very much.
542.
Section 21.
I'm sorry, I'm bending down to look at my notes and I'm not being as clear as I should. I apologise.
No.
542. This Act came into force in England and Wales on the 1st of December 1977. And we see from the head note that it was passed on the 29th of July. So it came in barely 5 months after it was passed. Section 1, page 529, gives the definition of homelessness, which doesn't have provision for reasonableness of continued occupation. That came in later. And then at section 4, subsection 5, page 531, is the main housing duty. Subsection 5, where they are satisfied, and so on, their duty, subject to section 5 below, its local connection, is to secure that accommodation becomes available. So the wording is very, very similar to the modern day. And in fact, I think it's common ground in this case. It's materially the same.
Sorry,
So far as there's a slight difference in language.
forgive me, the section, the main housing duty is
Oh, I'm so sorry. It's at 532 at the top of 532.
2.
Is to secure that accommodation becomes available for his occupation.
Yes.
Yes. Thank you.
So, and that's very similar to the language of the modern day. Insofar as there's a difference, Lord Hope has said that there's not a material difference. There's a reference in our case to that.
Thank you.
And just completing on this Act, section 13 at page 537, there's provision for finance, property and staff. Subsection 10 at page 539, there's a reference to charges to the housing revenue account. The housing authority shall debit to the housing revenue account costs and expenses incurred carrying out their duties under this Act, only insofar as they conform to relevant legislation. And in section 14, page 539, there's provision for transfers of property and staff. And I think an order was made under section 14. It's not in the bundle, but can be provided if necessary. So that was the 1977 Act. What I invite the court to do now, please, is to look at one case before the 1977 Act, quite an important case, and then to look very briefly at some decisions after the 1977 Act, which helpfully in our submission explain its purpose. The earlier case is the case called Bristol Corporation and Hendy, and that, Lords, will find at page 1547.
page? I think,
1547.
not sure.
Well, it starts at the foot of the page.
At the bottom, is it?
Where's Hendy? I've got it here. Yeah, 1547. Does the Lord have it?
I do.
Thank you. This is a decision of the Court of Appeal in 1973. It's not a case on the Housing Act. It's a case on the then new Land Compensation Act 1973. And judgments were given by Lord Denning, the Master of the Rolls, and Lord Justice Stamp, Lord Justice Scarman as he was. And picking it up at page electronic number 1548, at the beginning of his judgment, Lord Denning, this case raises a point under the Land Compensation Act. And essentially what had happened is that the local authority had made a closing order as a result of which the applicant was required to leave their property. And then at page 500D of the law report, that's electronic page 1548, the Master of the Rolls sets out the nature of section 39 that was relied upon in this case as requiring the local authority to accommodate as a result of the closing order. And Lords will see section 39 says, where a person is displaced from residential accommodation on any land in consequence of the making of a housing order, and suitable alternative residential accommodation on reasonable terms is not otherwise available to that person, then subject to the provisions of this section, it shall be the duty of the relevant authority to secure that he will be provided with such other accommodation. And we say that there's some similarity between that duty and the one that we find in the main housing duty. And the question, one of the questions for the court, the second question for the court is whether it should make an order of mandamus compelling the local authority to provide suitable alternative accommodation. And at page 501B to C of the law report, that's 1550, 501B to C, the Master of the Rolls rejected the submission that there should be an order of mandamus. And he said, I think that the local authority fulfil their duty when they do their best, as soon as practicable, to get him other accommodation. No doubt they can take into account the fact that he'd been displaced under a closing order, but it does not mean that he takes priority over everybody else in the housing list. His circumstances must be considered along with others and a fair decision made between them. And then in his short concurring judgment, Lord Justice Stamp, it's F to G, the same page. I agree, it is not, I hope and believe, every failure on the part of a local authority to carry out its duties that may be corrected by an order of mandamus. If it were so, the courts would, as I see it, be taking over the whole control of the government of this country. And then Lord Justice Scarman, same page, I also agree. He says at the foot of that page, I accept the submission that section 39 not only imposes a duty upon the local authority, but also confers a legal right upon the person displaced. But importantly, in terms of the question of mandamus, at page 503G to H of the law report, and that's page 1552, Lord Justice Carman says, about 10, 12 lines from the bottom between G and H, but even if I was wrong, if I be wrong on that view of this section, I'm satisfied that mandamus ought not to issue. In my judgment, if in a situation such as this, there is evidence that a local authority is doing all it honestly and honourably can to meet the statutory obligation, and that its failure, if there be a failure to meet that obligation, arises really out of circumstances over which it has no control, then it would, I think, be improper for the court to make an order of mandamus compelling it to do that, which either it cannot do, or which it can only do at the expense of other persons not before the court, who may have equal rights, and the applicant and some of whom would certainly have equal moral claims. Well, can I just invite the court to turn to page 885. So sorry. Lords, give me a moment. So 1800, 1800. This is a publication of the celebrated lecture by Lord Bingham, Should Public Law Remedies Be Discretionary? And at page 1800, under the subheading No Useful Purpose, Lord Bingham says, the court has exercised its discretion to refuse declarations or to refuse relief, or where a public body has shown that it is doing all it honestly can to comply with its statutory duty. And that's footnote 77, which is the reference to Hendy. We've put other texts in the bundle for the court's consideration. They too refer to Hendy for the same proposition. Now, the reason we invite the court to look at Hendy, because, of course, that represented the position in 1977, and Lords will know that it's a well-established principle of statutory interpretation that an act is not to be taken as affecting a change in the common law unless by clear, either by express provision or clear implication. So that was the common law background, as it were, to the enactment. Can I move, therefore, to some important decisions, and I'll take them as quickly as I can and then sum up why these are relevant to the point that I'm making on the 1977 Act. And the first is at page 976. These are all well-known cases, and this is the case of Dinn and Wandsworth. This was an early decision of the House of Lords on the 1977 Act.
I'm so sorry, just before we move away from Hendy and Lord Bingham's lecture, are you saying that that is a different test in relation to the principle governing mandatory relief than that stated by the Court of Appeal?
What we're saying, my Lord, is that that is it's on a different statute, although there may be a similarity between the two. We simply say that that is a recognition that when it comes to enforcement of a duty, that the rights or aspirations of others may be a relevant consideration. Now, maybe I don't have to take it further than that, because in fact, when we look at the judgment in the Court of Appeal, it seems that Lord Justice Lewis accepted that, at least up to a certain point. It's only a part of the building block in this submission, but I simply put it before the court to show what the common law position was in 1977.
Sorry, just on that, I mean, the Court of Appeal, in our case, at paragraph 134, summarises the correct approach, but they do so after reminding themselves of what Lord Justice Scarman
Yes, I
said.
understand that.
And surely they're addressing the common law principle in the same way that...
I understand that, Lord. I'll come back to that when I address the court on the judgment itself. I simply want, all I want to do, I don't want to take more time than necessary. I want to show what the position was when the original Act was passed, and hopefully this will become clearer as I develop the submission.
Right, but just before we move away from this, I appreciate you're going to come back to it. Can you give us a preview as to whether you're going to say that the Court of Appeal has misstated the test to be applied in paragraphs 133 and 134?
No, I don't think that's our case. We're going to be saying that's wrong.
All right, thank you.
But, I'll
That's
come
all I
back to
wanted
that,
know.
Lord, yes. But- Well, I'm now inviting the court to look at some cases on the 1977 Act and inviting the court to draw some general conclusions from them. The first case is Dinn, which is at page 976. Dinn and Wandsworth. This was a case on intentional homelessness. And I draw it to the court's attention because at page 663, E onwards for the law report, that's at page 982, Lord Wilberforce sets out some important points to bear in mind. This is at G2H. In applying and interpreting this Act, there are several important points to bear in mind. First, that it is designed for the express purpose of bringing families together. Secondly, it forms part of a complex of duties which local authorities owe to categories of persons seeking housing. These persons are normally placed on a waiting list, in some areas a very long one, and are given accommodation according to a point system of priority. Inevitably, every allocation of priority housing to homeless persons must have the effect of deferring the hopes of persons in other categories, some of whom have been waiting for a long time. And if we could just go over the page at electronic page 983, this is Law Report 664A to B. Fourthly, as the Act recognises, conditions may and do differ greatly from one authority to another, and in administering its provisions, they may be taken into account. The Act must be interpreted in the light of these matters with liberality, having regard to its social purposes, and also with recognition of the claims of others and the nature and scale of the local authorities' responsibilities. Lord, I'll just, if I may, give the references, then I'll make the submission. So that's Dinn. And then we come to the well-known case of Pulhofer, which is at page 1146. Oh, yeah. What page? 993. Yeah. I'm grateful to my friend. He has asked me to go to 993 of Dinn, and it's the speech of Lord Lowry, page 993, Lord Lowry, E to F. As in other cases, the real contest here is not between the homeless citizen and the state. The duty of the housing authority is to hold the balance fairly among all homeless persons and to exercise a fair discretion according to law, while your Lordship's task is to declare the law relevant to this case. Thank you. Thank you. And then to...
Just to be clear, so Dinn was a case about whether the duty had been breached at all.
It's about intentionality, whether the local authority was entitled to find that the applicant's homelessness was intentional. That was the context. I'm not for that reason I take the court to this judgment, this decision, but simply because their lordships were drawing out general observations. The submission I'm building is that from the early cases and confirmed by some later ones, the nature of this duty becomes much clearer. That's the submission I'm working towards, my Lord. So if I could just go through those cases and then I'll draw the threads together.
I don't want to interrupt you more than necessary, but again, I'm just slightly puzzled why we're spending so long on cases which go to the nature of the duty, where it's accepted in our case that there has been a breach of the duty.
Yeah, I understand it, my Lord, but the question is whether the local authority has taken reasonable steps to perform the duty. A mandatory order is required to compel it.
Right, but it hasn't. So in terms of breach of the duty, whatever the test is, it hasn't taken the relevant steps which it should have done according to its duty.
Lord, yes, and the question is, in enforcing that duty, is the court entitled to have regard to resources, the local authority's resources?
Right, okay, thank you.
So Pulhofer is at 1146. And the passage I rely on is at 1173. It starts as the beginning of Lord Brightman's speech. This is a very well-known case. I think what I might do to save time, simply give my lords the references. But at page 1173, page 511 of the law report, between A and B, Lord Brightman refers to the Act as part of a large volume of public housing legislation, generated a massive litigation and so on. And the important passage for present purposes, here at page 1179, B to D of the law report, there are several features of the Act which, in my respectful opinion, have to be borne in mind. The Act bears the word housing in its short title. It's not an Act which imposes any duty upon the local authority to house the homeless. As the long title indicates, its object is to make further provision as to the functions of local authorities. It's an Act to assist persons who are homeless, not an Act to provide them with homes. It's an Act which came into operation in England, Wales only 4 months, in Scotland 7 months after it was passed, not sufficient time to enable local authority to achieve any dramatic increase in their available housing stock. Intended to provide for the homeless a lifeline of last resort, not to enable them to make inroads into the local authority's waiting list of applicants for housing. Some inroads there are probably bound to be, but in the end, the local authority will have to balance the priority needs of the homeless on the one hand and the legitimate aspirations of their housing waiting list on the other hand. And finally, I'm not going to read it because it's so well known, at page 1180, B to F, is the warning about proliferation of judicial review challenges in this area. So that's Pulhofer. And then O'Rourke, which is at page 1111, is, we respectfully submit, a particularly helpful case. Again, a decision of the House of Lords. We've moved on. This is, in fact, a decision on the Housing Act 1985, but it's identical because the Housing Act 1985 was consolidation. And the question in O'Rourke was whether a breach of duty under the homelessness legislation sounded in damages. And the House of Lords held that it did not. And can I invite the court to look at the essential reasoning of Lord Hoffman, who gave the main speech. It's at page 1116 of the bundle, of the electronic bundle, and C to F of the law report. And this where Lord Hoffman refers to certain contraindications which make it unlikely that the Parliament intended to create private law rights of action. It says the first is that the Act is a scheme of social welfare intended to confer benefits at the public expense on grounds of public policy. Public money is spent on housing the homeless not merely for the private benefit of people who find themselves homeless, but on grounds of general public interest, because, for example, proper housing means that people will be less likely to suffer illness, turn to crime, or require the attention of other social services. Expenditure interacts with expenditure on other public services such as education, the National Health Service and even the police. It is not simply a private matter between the claimant and the housing authority. According to the fact that Parliament has provided for the expenditure of public money on benefits in kind such as housing the homeless does not necessarily mean that it intended cash payments to be made by way of damages to persons who, in breach of the duties, have unfortunately not receive the benefits which they should be done. So there's no damages, and I invite the court to consider Lord Hoffman's essential reason for that. And then finally from the House of Lords, a case I've mentioned before, and that's the Runa Begum case, which is at 875. And this was the case, the first in those, the trilogy of Article 6 cases that I mentioned earlier. And in his speech at page 885, that's page 440 of the Law Report, paragraph 9, Lord Bingham says, in approaching this question, I regard three matters as particularly pertinent. One, Part 7 of the 1996 Act is only part of a far-reaching statutory scheme regulating the important field of social housing. Administration of that scheme is very largely entrusted to local authorities. While the homeless provisions are, of course, intended to assist those individuals who are or may become homeless, there's a wider public dimension to the problem of homelessness, to which attention was drawn in O'Rourke, the passage we've just seen. And Lord Millett makes a similar observation at paragraph 79, but I needn't go to that now. And then finally to the one Court of Appeal case that I seek to take the court to on this, and that's Ali Biquet at page 813. This is a 2018 decision of the Court of Appeal. This is on the 1996 Act. This is another main housing duty case concerning out-of-area placement policy. And I took the court earlier to the guidance offered by Lady Hale in the Zelamesso about having policies. And the local authorities concerned with this case had such policies, and there were challenges under those policies. But I take the case, your lordships, to it purely for the purposes of paragraph 36 and 37, which are 826. Firstly, there's a reference at 30. So this is Lord Justice Lewison. And firstly, there are references to A. Croydon and Poshte, the references I've already taken the court to, and in particular the reference to, this is under the subheading Judicialisation of Welfare Services, and there's reference to the, at 36, including allocation of scarce resources. And then there's this, 5 lines from the bottom of paragraph 37 of that page. I consider that whereas here the policy in question relates specifically to a group, all of whom are within the same category of persons to whom the individual duty is owed, that's the main housing duty, I should say, an authority must be entitled to carry out a similar balancing exercise. This is an exercise with which the court ought to be very wary of interfering. To put the point another way, the individual duty is owed both to the particular applicants and also to all other applicants in relation to whom the authority has accepted the full housing duty. It must try its best to give effect to those concurrent duties. The court must be wary about imposing onerous duties on housing authorities struggling to cope with the number of applications they receive in the context of a severe housing shortage and overstretched financial and staffing resources. That said, the court is the guardian of legality. It must not hesitate to quash an unlawful decision. So, my Lord, drawing the threads together, and this is pair 47 of our case, we say that we rely on those cases for supporting the proposition that this legislation has a much wider social purpose. As Lord Hoffman has explained, it interacts with other services. And that, properly understood, the local authority owes concurrent duties, a duty, a legally enforceable duty to the individual homeless person, but also a duty to all other applicants owed similar duties. So performance of the duty to an individual homeless person is not, we say, to be performed in a legal or factual vacuum. And that's another reason we say this would be a convenient moment for me, my Lord, building the submission, why resources are relevant to the performance of the main housing duty. My Lord, my next point is...
You said that the local authority owes current duties to the applicant, and did you say all other homeless
Yes,
persons?
it's what Lord Justice Lewison described, my Lord, as concurrent duty, properly understood, because of the social utility of this legislation, the importance of this legislation, and its interaction.
I understand.
Yes, I'm grateful. My next point is to demonstrate that availability of accommodation, which is another way of looking at resources, we say, is already an established consideration for the exercise of remedial discretion in relation to the main housing duty. I can begin that, my Lord, or otherwise it may be a convenient moment to take a short break.
We'll take a short break.
Can I just say that I hope that I've not taken longer than the Lords would expect on the matters taken so far. It's necessary for our submission. I think I'm on track to finishing, if not on time, hopefully, certainly before. And I've heard.
Thank you. Good. We'll rise for 5 minutes.
Thank you, my Lord. The third point, and I can take this shortly, is that the availability of suitable accommodation is already an established consideration for the exercise of remedial discretion in relation to the main housing duty. And I can deal with one I take it by reference to one citation, and that's in the case of Slattery and Basildon, page 1670. Case begins at 1661, but at 1670, this is another main housing duty case, and it's the judgment of Lord Justice Briggs, as he was, with whom Lord Justices Sullivan and Arnold agreed. Mr. Justice Arnold agreed. And at 1670, Lord Justice Briggs refers to the case of Cadona, judgment of Lord Justice Ord, at para 38, and where the indented paragraph at the top, paragraph 30, Lord Justice Ord had said, and fourth, where it is shown...
Sorry, you're at the top
page
of
1670
and fourth. Yes, got it. Thank you.
And it's actually paragraph 30. It's at the top of the page. This is Lord Justice Ord, para 38 of the Cadona case, and it begins the citation and fourth. Does my Lord have it?
Yes.
Oh, I'm sorry. And fourth, where it is shown that a local housing authority has been doing all that it could, the court would not make an order to force it to do the impossible. Its duty was to secure the availability of suitable accommodation within a reasonable period of time, the reasonableness of that period depending on the circumstances of each case and what accommodation is available. Then there's reference to Mr. Justice Collins' case called Ex parte Begum. And a submission is made at para 31 as to what Lord Justice Ord meant by that. And at 32, and this is the ratio of this case, Lord Justice Briggs says, I do not read 38 of Lord Justice Ord's judgment in the Cadona case in that way at all. In my view, it is concerned with the predicament of a local housing authority, which arises where it becomes apparent that it has no accommodation immediately available with which to satisfy even the Wednesbury minimum test of suitability. Pausing there, that's this case. In such circumstances, the court will give the housing authority a reasonable period of time in which to find it by acquisition, conversion, repair, or any other suitable manner. The only point we take from that, respectfully, is that there is linkage between the remedial discretion in the case concerning the main housing duty and what is available, which is another way of looking at resources. That's the point, simply, that there's already recognised authority. For the court's note, it might also be helpful to see what Lady Justice Arden, as she was, said in the Airways case at paras 63 to 66 at page 1225.
Just on this, this is the case law that was reviewed by the Court of Appeal in the Birmingham case, wasn't it, on the first issue?
Yes, but they used it for a different...
They were taking into account when they came to their view, not now under appeal to us, that the duty is not a duty to house within a reasonable time. If it arises, it's a duty that arises as soon as it's found to incept.
Yes.
So I'm not quite sure how, if it's interpreted in that way, both Cardona and Slattery, how it helps us in relation to the issue before us, which is a matter of remedial discretion.
Well, the reason Birmingham relied on that passage from Lord Justice Ord was to support the proposition that the duty once owed can be deferred. Birmingham's scheme was to accept a person that has owed the main housing duty and to put them on a deferral list. That's not a position that Croydon aligned itself with. It accepted that the duty was immediate and binding, enforceable immediately. So they were relying on that passage for a different reason. And respectfully, quite rightly, the Court of Appeal in our case rejected that. We accept that was right. We're looking, and Lord Justice Briggs in Slattery respectfully just puts the position right. He says, no, Lord Justice Ord wasn't saying you can defer the duty. What he's saying is where you're in the predicament that you owe the duty but you don't have the accommodation, the court will give you some time. Now, in fairness, it may be that Lord Justice Briggs, what he had in mind was deferring the period of which an order would be made. He didn't say that, but I accept that that might be one interpretation. But what we seek to draw from it is that the court is accepting the basic proposition that availability is at least potentially relevant to the exercise of remedial discretion. That's where we're at in this case. Lord Justice Lewis, in our case, says that resources are not relevant, per se, to the enforcement of the main housing duty. And we say, on this appeal, that's wrong.
I mean, it's true that Lord Justice Lewis, in our case, says that, in general terms, it's not enough for the local authorities to come forward and say, we just can't do it, we're too financially stretched. But in the way that he then analyses what they would have to show, he clearly is having regard to resources. It's just that the resource restrictions have to be explained more precisely and in a more focused manner. So,
clearly we have submissions on that in the third part as to what Lord Justice. But ultimately, the Court of Appeal.
Well, first of all, isn't it right that the Court of Appeal has accepted that resources are relevant, albeit at that second stage? I appreciate you say that's wrong.
Yeah.
But do you not accept that they are treating resources as relevant in their approach?
I do in part, because certainly Lord Justice Lewis we'll come on to this. Obviously, I have submissions on my third part in relation to that. But ultimately, of course, Lord Justice Lewis and the Court of Appeal allowed the appeal, set aside the decision of the deputy judge because of the reference to resources. So ultimately, it was a complete knockout blow. So, but I respectfully accept, acknowledge and agree with my Lord's observation. We'll come on to that.
These cases are just showing you can have a reasonable period of time. They don't show you can kick it off into the long grass.
Lord, I do accept, I've just made that point, I accept that is...
Well, it doesn't get you anywhere in this case, does it?
Well, All I rely upon it, my Lord, for is that, as I said, it's a recognition that what is available may be a relevant consideration. Lord, and then the fourth point, the last point that we make in relation to this question of the relevance of resources to the performance of the main housing duty is that Section 193 cannot itself be interpreted as excluding consideration of resources. So we invite the court to look at the words of 1932. Which is at 732.
I mean, forgive me for picking up on this. I don't think anyone's saying that Section 1932 does exclude looking at resources. In fact, rather the reverse. Part of the reasoning of the Court of Appeal is that one does have regard to resources under Section 1932, and that they take that as an indicator as to the more limited role that resources play at the remedial discretion stage.
No, my Lord, respectfully, that's not what the Court of Appeal found. What the Court of Appeal found, as I say, I will be dealing with these points in Part 3, but I'll answer my Lord's point now, of course, question now. What the Court of Appeal found is because the local authority has the ability to take resources into account in deciding the preliminary question or whether it's reasonable for a person to continue to occupy their present accommodation, or whether that's suitable, because they have that power there, they're deprived of it when it comes down to the duty. Once the duty is owed and it's accepted that the present accommodation is unsuitable, then there's no allowance for resources. That's the decision of the Court of Appeal. That's the decision that's being appealed against, and that's the decision that I seek to address in my submissions. So respectfully, we don't agree that the Court of Appeal was accepting that resources are part and parcel of the duty itself, leading up to the duty. But once the duty is owed, then resources are out of the picture.
But you accepted that there was a breach of the duty?
Yes.
That was the premise of the whole argument.
Yeah, no, yes.
So the court didn't need to determine whether there was a breach of the duty.
We weren't asking the court. I'm sorry, sorry. We weren't asking the court to determine whether there was a breach. That was the acceptance. We were concerned with whether the court should make a mandatory order compelling Croydon to perform the duty. And the question was whether resources were relevant to that exercise. I do understand that, but I appreciate the court took some time in the Birmingham case to interpret Section 193, but there were different issues that arose there. Oh, yes.
So they didn't deal with this point that you're addressing us on now, in other words, the precise context in which resources come into the nature of the duty itself and whether it's been breached. Because it wasn't an issue.
They did in issue 5, we say. They had decided that the duty is immediate. That was issue 1. That was Birmingham's case, non-deferrable. And in issue 5, they asked themselves, what is the correct approach to enforcement of the main housing duty and whether resources are a relevant consideration to that. That's what Croydon is concerned about. That's why Croydon is here before the court.
I interrupted you when you were just beginning a submission, as I noted it, that the main duty in Section 193, subsection 2, does not exclude consideration of resources.
Yes.
And the reason for interrupting was to say, well, no one suggests that it does. So
I think that's crisis case, insofar as we understand it. But if the Lords don't feel that that's going to be of assistance, then I shan't pursue that point. All right, it's an obvious point, but if one looks at 193, in conjunction with Section 206.1, that's 206.1 tells them the 3 mandatory alternatives for performing it. We say that resources implicit in that statutory provision. Put it this way, the local authority may discharge the duty by methods A, B and C. How they decide between those three methods, or whether they go from one method to another, is informed by resources. And it's actually, although this case is about the main housing duty, 193, the reasonable steps actually refers to 2061, the 3 steps. Local authority, you must demonstrate what steps you have taken by reference to 206, 1, 2, 3, own stock, some other person, advice and assistance. You've got to demonstrate by reference to those that you have taken all reasonable steps to perform your duty. So the actual context brings us into 206. And the submission is simply that if you look at 206, the range of options, it's at
page 765, I think.
Yes, thank you. 765, thank you, my lord. Local authority may discharge their fund only, I've read it before, so there are 3 ways. So the local authority can choose one of those ways, or it can switch from one to another, and so forth. Perhaps a better way of illustrating my point is to look at a passage in the Code of Guidance at 1742. 1742. This is chapter 16 of the Statutory Code of Guidance to which local authorities shall have regard. And this is in the chapter entitled Securing Accommodation. And then over page 1743, paragraph 16.8, where a housing authority has a duty under section 1932 to secure accommodation for an applicant, it should consider where availability of suitable accommodation housing allows, securing settled rather than temporary accommodation that will bring the duty to an end in the immediate or short term. So that brings resources into full focus in the decision whether you go down one route or another. Well, I'm conscious of time. I want to make progress. The summary of that section of the submission on the relevance of resources to the performance of the main duty is that the main housing duty is inextricably linked to resources, so that when a court is called upon to enforce it, it cannot exclude from its consideration, or should not exclude, depending on the circumstances of the case, matters of resources. Lord, what I'd like to do now is to proceed to ground 1 of the appeal, and because I've covered a good deal of the background here, I can hopefully pick up a little speed. But this is ground 1 of the appeal, issues 2A to C of the statement of facts and issues, and it's Croydon's case at paras 35 to 64.
Paragraph, sorry.
35 to 64
Thank you.
of Croydon's printed case. The Lords have seen the judgment of the Court of Appeal. It's in the key documents bundle, tab 8. And Lords have seen that the judgment addresses 5 issues. Issue 1 was Birmingham's case. The main housing duty is to be interpreted as a duty to secure accommodation within a reasonable time. Issues 2 to 4 all concern Birmingham cases. And issue 5 concerned both Croydon and the 3rd Birmingham case, Mr. Ahmed. Lord Justice Lewis gave the main judgment, with whom Lord Justices Underhill and Peter Jackson agreed. Lord Justice Lewis's decisions on resources here, his conclusion, first of all, his conclusion on issue 1 is at para 108. That's the conclusion on issue 1. It's an immediate duty. And the conclusion on resources is at para 131, which is at page 263. 131. And halfway down that paragraph, resources and financial constraints on the housing authority are relevant to whether it is reasonable for a person to continue to occupy accommodation or in assessing whether the current accommodation is suitable. Once a duty is owed, however, and once the current accommodation is found to be unsuitable, financial constraints cannot justify non-compliance with the duty imposed by Parliament and would not of itself justify refusing to grant an appropriate order intended to bring about compliance with that duty. So that's the nub of Lord Justice Lewis's decision. And at 141, page 265, Lord Justice Lewis repeats that I would not regard budgetary constraints as relevant to whether a mandatory is appropriate once a housing authority has accepted that the person's homeless, his current accommodation is unsuitable. I accept the limited number of suitable properties available may be relevant in assessing whether a local housing authority has done all it reasonably can, but constraints on resources are not a reason for the complying with the duty imposed by Parliament. It is clear from paragraph 82 of the Deputy Judge considered that the limited resources available Croydon was a significant factor. So it was paragraph 82 of the Deputy Judge's judgment that fell into error. So two short points to note about Lord Justice Lewis's approach. Firstly, it was in some respects expressed in equivocal terms. At 131, it was said, reference Parliament and would not of itself justify refusing the grant of appropriate order. At 132, 4 lines up from the bottom, the lack or availability of suitable properties may not persuade a court that a local housing authority has taken all reasonable steps. And at 134, the top of page 264, second full sentence, it is unlikely to be sufficient to refer generally to the demand for housing or shortage of accommodation. Lord Justice Lewis refers to the Hendy case at 133, as my Lord Sales has noted. And accepts at 137, last 3 lines on the page 264, that the fact there are a limited number of satisfactory properties available may be relevant to whether the housing authority has done all it reasonably can.
Well, I think that's the point that I was putting to you, that it seems inherent in Lord Justice Lewis's approach that one does have regard to resources. The point seems to be a relatively narrow one, perhaps appearing from paragraph 134, that it's not enough just for a housing authority to come forward and say we're subject to financial limitations, therefore can't comply. The issue, so far as Lord Justice Lewis is concerned, seems to be more how much detail the housing authority offers to explain why it is not practicable for or reasonable to expect them to comply with the duty. So, but taking account at that level of what resources are available to them.
But, my Lord, ultimately the Court of Appeal found that the judge fell into error. To illustrate this, we need to see, obviously, focus on what the Deputy Judge did at 82 and why that was felt to be beyond the scope of remedial discretion. And in terms of the reasoning for that decision, Lord Justice Lewis at paragraph 130 page 262, 3 lines down. Before that duty arises, the authority would already have taken into account general housing conditions in their area, the limits on their housing stock and the limits of their resources when deciding whether it is reasonable for the individual to continue to occupy.
Or in deciding whether the accommodation is suitable.
Lord Justice Underhill agrees with that in paragraph 155. So the decision appears to be that there's great scope for looking at resources before you get to the point of accepting the duty. But then once the duty bites, then subject to my Lord Sale's point, they're out of the window. Resources don't come into it. But really what we need to do on ground one, in my respectful submission, is to see how the Deputy Judge dealt with it. But can I just, before then, and I'll deal with it as quickly as I can I just make a short submission as to why we say that too much emphasis was placed on this ability of the local authority, this is para 130, to take general housing conditions to look at resources at the question of whether it's reasonable to continue to occupy the present accommodation or whether it's suitable. Why we say that that is not a sufficient reason justifying the ultimate conclusion. And we set this out in para 58 of our case. Much of this reasoning centres around that provision in section 177, subsection 2, which says that in assessing reasonableness, regard may be had to local housing conditions. I took the court to that. The first point is that wasn't part of the original Act of 1977. It came in 9 years later as a direct response to the pull-off. Okay? So that can't be a reason for justifying certainly not the original duty. Secondly, there will be a whole host of cases where there's no scope for the local authority finding that the existing accommodation is reasonable. The most obvious one of which is where the applicant has no accommodation, where they come within that first class of homeless under section 175, the street homeless. There's no accommodation to assess. So that reason can't apply in that sort of case. Secondly, we see from the legislation and from the statutory inference made under it that there are a wide range of circumstances where the local authority cannot regard accommodation as suitable. For example, where the applicant runs the risk of violence or domestic abuse. That's section 1771. Any of those circumstances to which the statutory instruments apply, where it's not affordable, where the location is wrong. Thirdly, where the accommodation falls below the Wednesbury line for suitability. So there's considerable protection written into this legislation against the local authority construing too liberally the right to factor in local housing conditions, and it simply wouldn't apply in many cases that I've indicated. So as a reason, it wasn't one that was there at the origin of this duty, and it's not one that applies across the board. So we say very respectfully, it's not of itself sufficient to justify, however one construes the judgment, that's certainly not sufficient to justify an absolute prohibition, exclusion from the judge's discretion of looking at resources.
But the point is, isn't it, that you've got to satisfy the judge that it's impossible looking at the situation on the ground. And it's not good enough to say, well, I haven't got the money in my budget.
No, Lord, we come to this court making it absolutely clear what a local authority cannot do in response to an application for a mandatory order when it's in breach is to just lay out its resources and no more. Absolutely, that is not Croydon's case. Croydon's case is the duty is immediate, the duty bites, the duty is enforceable by the individual. The local authority, however we describe this in terms of reversal of burden of proof or whatever, the local authority must lay the foundation. It must demonstrate that it's taken all reasonable steps. The only question is, can it invite the court to consider, to factor into those steps, its resources? Now, this is not a question of getting out of hand. We respectfully say that the way the Deputy Judge has dealt with this demonstrates how a judge can handle responsibly the consideration of resources without allowing that to dominate. We respectfully say it's a model judgment, an example of how resources should responsibly be taken into account without not allowing that to dominate. One can see clearly the concern that this is a statutory duty, and if the local authority can simply say we've got no money, we can't comply with it, that is deeply unattractive. That is collapsing the duty into a power. We accept that completely. Not our case. Our case is that you cannot exclude resources. It's a matter for the judge as a matter in terms of the remedial discretion as to whether they are to be taken into account or not. There'll be cases where they're not.
Does it?
Clearly, I'm so
sorry, but does that not require the judge to look at the distribution of resources between competing pots within the local authority?
No, it doesn't, my lord, no. That, there's a technical reason that doesn't work, and that's the housing revenue account, because the crossover of funding, the housing services in general, there are exceptions, the finance is ring-fenced, the housing revenue account funds them, and it can't draw, generally speaking, can't draw from the others, so it can't. We respectfully acknowledge my lord's concern, and this was one raised by the House of Lords in the Tandy case, that it draws the court into this argument about how the local authority should spend its money. The way we put it to the Deputy Judge, this is our DOM point and the way the Deputy Judge accepted it, is you look at a snapshot, what the position is on the ground now, and take that into account. We are not suggesting for a moment that the court, the judge, must get involved in looking at the distribution. That would be quite wrong. All we're saying is that you cannot logically exclude consideration of resources, and we need to look at the way the Deputy Judge has dealt with that when exercising discretion. Can I come on to the judgment and how he dealt with it? It's key documents, page 273. The Deputy Judge deals with the facts and then sets out at para 22 the detailed evidence that was given on behalf of Croydon by Simon Beasley, its Housing Operations Manager. At paragraph 23, page 282, para 23, the Deputy Judge sets out the three grounds for judicial review. The first one, what relief should be granted to the claimant in respect to the defendant's admitted breach. At para 36, the Deputy Judge accepts, page 287, para 36, accepts the duty is immediate. At paragraph 56, page 295, he summarises Croydon's submissions. And then at 61, he begins his consideration of ground one. And it's at 81.
It's a very long run-up, but finally he exercises his discretion in one paragraph towards the end of the judgment.
Lord, there was a purpose behind it, but I respectfully take the Lord's point. 81 sets out his decision and the reasons, 80 in all, supporting it. And at 82, the encapsulation of that, he gives particular emphasis to the first factor, which is the level of amenity the present accommodation provides and the impact on the claimant. And then he refers to a number of countervailing factors, including limited resources available to the defendant and the position of other applicants who are also waiting for housing. So, where then did the Deputy Judge go wrong? 82 is the paragraph that Lord Justice Lewis identifies. There the judge is looking at Deputy Judge is looking at limited resources and the position of other applicants who are also on the waiting list. Well, Lord Justice does seem to accept that you can have regard to other applicants, the Hendy point, but it's the resources that's the problem. Resources are mentioned in that assessment. They're mentioned in Roman 2, which is at page 308, half the way down that paragraph. I accept Mr. Beasley's evidence that the defendant is doing what he reasonably can, consistent with the proper application of policies and limited resources available to fulfil its statutory duty. That is really just recording.
It's really subparagraph 5.
It's paragraph 5, Michael.
5, where seems to be looking at the amount of the budget.
Yes. Exactly
what I thought you'd accepted you can't do.
It's the 67 million, my lord. That is probably the nub of it, the reference to that. Can I just... before addressing, can I just draw the court's attention?
I mean, are you defending little 5?
Yes.
As a correct approach?
Yes, indeed. Well, certainly on the facts of this case, which is the second limb of ground 1, if we just turn to, please, to paragraph 88 of the judgment, paragraph 313, this is in relation to ground 2. Ground 2 was that the local authority had failed to make reasonable adjustments for the purposes of the Equality Act. And at 88, the Deputy Judge identifies the policies or practices that are under challenge, and they include Roman 1, the resources, staffing that would be devoted to identifying suitable temporary accommodation, and Roman 3 is the budget which would be spent on temporary accommodation. So it was the claimant who put in issue the resources of local authority, albeit in relation to ground 2. And also, this is recorded at 81 Roman 7, page 310, that what the claimant was asking the local authority to do, amongst other things, was to consider purchasing her a property. Now, the submission is that it was in connection with that suggestion that the Croydon can discharge duty by purchasing a property that Mr. Beasley gave his evidence about the projected budgetary overspend of 67 million. And we see that from the appeal documents bundle 426. This is 424, the statement starts, and there are two references in this detailed witness statement to the £67 million overspend. The first is at paragraph 8, which is at 426. And that has to be read in conjunction with paragraph 9. And the second is at paragraph 127. In both cases...
What page is it?
I'm so sorry, my lord, 435.
453.
Apologise.
What?
53.
Sorry, 453. 453. So there are two references in the witness statement to the £67 million projected overspend. Both of them are put forward in the context of the proposition that Croydon should purchase.
Can I just ask for clarification here? The projected 67 million overspend, is that by Croydon in respect of all its activities?
Yes. Yes, it's not just housing.
Well, what was the relevance of the reference you made earlier to the housing finance account?
Well, my lord, the crisp answer is not a great deal of relevance. I understand that. What Mr. Beasley is giving his evidence. He perhaps didn't...
Is it right that Croydon could move money from one activity unrelated to housing, because I got the impression that you were saying that housing was a sort of separate entity almost within Croydon's activities.
Yes,
is that right?
That's right, but there are...
What's the relevance of 67 million?
No, the Lord, respectfully, I accept that point, your Lordship's point. The answer to the point is yes, it's generally ring-fenced.
Yeah.
There are exceptions, but Mr. Beasley is making a general point. It may be that...
well, it's not only he who's making it, you're making it. You've just taken us twice to this figure, and I want to understand, because it's a rather startling figure, but what is the relevance of that figure to the issue before us?
The relevance is this, that the witness gave evidence in response, specifically in response to the suggestion that in order to discharge its duty, Croydon goes into the private market and purchases her property. And he says, his evidence is, if Croydon did that, then in fairness it would have to do the same for the others currently above her on Part 6. That would cost a substantial sum of money.
Are you supporting that position, that Croydon would have to do the same for others above her in the Part 6 list?
Yeah.
Do you support that now?
Well, the submission is, he's saying that. It's simply...
I mean, I just don't know what I mean, I know he's saying it. You tell us why he said it. What I'm asking is what its relevance is today before us.
It's relevant to the way the judge deals with resources at Roman 5.
Well, what you're I mean, we're not concerned with what Mr. Beasley said. We're concerned with what you made of it in making your submission recorded in subparagraph 5.
Yeah, all I'm saying...
That resources are relevant.
Yeah, no, all
and
I'm
that
saying...
unchallenged budgetary decisions already taken must be the starting point. That seems to be a submission that the budget is relevant to the grant of relief, which I thought you disclaimed some time ago.
Your Lordship's right. The nub of the decision is at 81.5. That paragraph, I would respectfully suggest, is looking at the proposition that Croydon should purchase a property for the...
I don't think that's tenable.
Well,
I mean, because I mean, there are all sorts of ways, no doubt, in which Croydon could provide accommodation, of which purchase is just one.
Probably the least likely.
I mean, that was the point Lord Justice Briggs was making, that there are various ways it could be done, and if it was impossible to do it within 24 hours, then that, of course, would affect the injunction. But that,
except
I don't think you could read paragraph 5 as directed only to the question of purchase. I mean, it's a very general point that's being made.
Lord,
5, isn't it? We don't have the money, is the point that's being made.
Lord, yes. What the deputy judge is doing here is he's going through the various factors relevant to the question of whether he grants a mandatory order, having regard to the evidence that's been presented to him and the case that's been advanced on behalf of the then claimant. And part of her case was that Croydon should purchase a property for her.
What was your submission?
It's not the purchase of the property is not referred to in subparagraph 5, and the judge is reciting and referring to your very broad submission that the court must consider the wider context when considering the question of relief. And the wider context is the financial resources available. Well, it's nothing to do with any very specific issue about a purchase of a property.
Lord, that respectfully depends on how one reads the last paragraph in granting an order the terms which require the defendant to provide a property.
Well, that's not just purchase, is it?
No, I mean, it's explicitly not just purchase.
But Lord, the submission is simply that one of the options that was being put forward was to purchase. The cost of that...
The whole thrust of this is not focusing on purchase of a property, it's focusing on the provision of accommodation. How that's achieved, by purchase, by alteration, by leasing, whatever it is another matter. I think, with respect, I think you're wrong to focus just on purchase. The question is whether the court should make a mandatory order which will require Croydon to provide accommodation.
Yes.
That's the issue.
Secure, yes.
And whether resources, in this general sense, for example, the deficit of 67 million and so on, what part that has to play in it. That's the issue raised on this appeal.
Well,
and this is at the heart of the appeal.
Lord, I repeat myself. The submission is that paragraph Roman 5 here is looking at whether there is money in the present budget. Look at this is the DOM point. You are where you are.
Yeah.
Having regard to the evidence that Mr. Beasley gave in response to the one suggestion that Croydon should go into the open market. And making the very good point that the claimant hasn't sought to challenge any part of the defendant's budget or the allocation of resources to discharge its statutory duties. And bear in mind this is a challenge which is also brought under the Equality Act and allegations of a failure to reallocate resources to housing. So we say very respectfully, and in fairness to the Deputy Judge, the court shouldn't read too much into that paragraph. All that paragraph...
Well, are you saying that your submissions were only limited to the question of purchase? Because it doesn't look like it in the paragraph, but maybe the judge got it wrong. The starting point is what was your submission to the judge, which he's dealing with here?
56.
Yeah. On the... Well, it may be recorded there. Do we have your...
Yes. Well, I'm sorry, my Lord. 56. It begins, the submission that the court could not, when considering what relief to grant in the claimant's case, focus on her individual circumstances. It needs to take into account the position of other applicants. Pausing there, I've sought to make good that point before your lordships today. He submitted it would require a compelling case, which this is not. That's a reference to the facts of the case, for the court to make a mandatory order, knowing that there are other applicants who would lose out as a direct result. That's the sort of Hendy point. He submitted that the question of local authorities' resources was relevant to relief. Pausing there, well, I've made my submissions before the court today as to why they cannot be excluded. And I've made the points...
Sorry, that sentence makes it again sound as though you were making an entirely general point about the relevance of resources to relief, not just focusing on one particular option of going into the market.
Lord, if necessary, we can look at my skeleton argument on this, but as appears from Roman 5, I put the submission in the DOM way. The DOM way, it's clear your Lordships understand that point, Lord Justice Rick's judgment, which says that you've got to start somewhere, and the current year's budget is where you start. And the submission, I don't want to give evidence as to what I submitted. We've got to look, see how the Deputy Judge...
This is what you submit to us, I think.
The submission was that the court should take into account what is available at the moment in the general exercise of its discretion. I think that sense the submission I was making, and the Deputy Judge accepts that as part of his reasoning at Roman 5.
Can I just ask you a question on the last sentence of Roman 5? Because the Deputy Judge says that in granting a mandatory order to provide the defendant with a property, to provide the claimant with a property, the court would be either requiring the defendant to spend money it doesn't have, or to reallocate money from other public services.
Yes.
Now, would that be unlawful, or would it be lawful for the local authority to divert resources from one part of the budget to another?
From its general budget?
I don't know. I mean, it's got areas of expenditure,
yes,
obviously, housing, education, so on and so forth. He's saying it would be necessary for the authority to reallocate money from the provision of other public services. My question to you is simply, well, is that a complete bar? Would it be unlawful for Croydon to do that?
Within the housing budget, it wouldn't. The answer to your Lordship's question
would not be within
that would not be unlawful. It could.
What about more generally? Because the deficit he's referring to is a general deficit.
Yes, that's general.
So would it be unlawful to take money from another budget?
Within housing?
No, right across the board of Croydon's activity. Because I think that's what he's talking about, other public services. That's to say, public services other than housing. That's what the judge is there referring to.
Lord,
he doesn't suggest it's unlawful, but I just ask you a question.
I mean, this difficulty, I apologise, because if I had anticipated this might be a relevant question, I think in our case we might have said more about the housing revenue account, how it operates.
I think it's, if I may say so, if you're saying that Croydon can only use particular types of fund for housing, can't have regard to other funds, that goes to the very heart of this case.
It's not as general as that.
No. Okay.
Lord, I fear that I'm going to go over the adjournment. I'll pick up speed as much as I can. Yes. If that is necessary, then I'll see what I can do to answer my Lord Richard's point at 2 o'clock. But I'm doing the best I can to
Very well.
within the time.
Very well.
So we've made the submission that it's wrong to exclude resources per se from the ambit of the judge's discretion. We make the point that properly understood, the Deputy Judge didn't fall into error that he's responding to the evidence that was put before him. He's responding to one of a number of suggestions as to how the local authority can discharge its duty. And we say respectfully that that does not fall into the error in principle that is necessary for the Court of Appeal or for the appeal court to interfere with what is an exercise of remedial discretion. And I'm conscious of the fact the court does have our written case where it's more fully set out. Can I proceed to part 4, ground 2 of the appeal? This is issues 3 and 4, the statement of facts and issues, and in our printed case is paragraphs 65 to 68. Lord Justice Lewis expressed his reasoning behind this conclusion in a number of ways, but between paragraphs 143 to 145, 143 to 145. It was a conclusion that was directed in particular, I think, at those 3-bedroom wheelchair accessible properties that Croydon had been able to source for applicants on its waiting list. Lord Justice Lewis accepted at 144, he accepts that it would be unlawful for Croydon to make an allocation of accommodation to Miss Imam by way of a secure tenancy outside the provisions of the scheme. That's obviously quite right. But he said at 143 that if any such property were offered to Miss Imam under a non-secure tenancy, that would not constitute an allocation. The allocation scheme would not apply, and the higher priorities of those ahead of Miss Imam in the queue for wheelchair accessible property would not present an obstacle. So Croydon had failed to demonstrate, to show as a reasonable step in the performance of this duty, why it had not considered the possibility of using own stock for Miss Imam, albeit on a non-secure tenancy. And the purpose of the non-secure tenancy is that that would then not be an allocation for the purposes of Part 6, and so you wouldn't run into difficulty with priorities under Part 6. And we say very respectfully that that was simply not a conclusion that was open to the Court of Appeal. We make some general points in our case about the nature of the all reasonable steps approach. We respectfully agree with Lord Justice Lewis at 134 that the rationale for the test is if the local authority has taken all reasonable steps but has failed to do so, that can be taken as a good indication the local authority would not be able to comply with the mandatory order. We respectfully agree with that. We say all reasonable steps is not a formal reversal of the burden of proof. We accept it's for the local authority to lay the foundation because the local authority is better placed than the court. As Croydon did in this case, look at the detail of the evidence Croydon put in. And then it's for the court to consider whether those steps are reasonable. But the court does that as part of its supervisory role, with due deference. The all reasonable steps approach, and this respectfully is an important point, does not override the procedural requirements which require a claimant in judicial review proceedings to provide a clear and concise statement of grounds.
So just to pick you up on one point, you say that it's for the court to consider if the steps are reasonable, but it does that exercising a supervisory role with due deference.
Yes.
Is that right? I can see that it's a supervisory role in terms of judicial review to see whether there's a breach of the duty in the first place, and one has regard to the usual level of deference for that. But we're dealing with a case where it's accepted there has been a breach of the duty.
Yeah.
So isn't then the picture that really it's Croydon, which is in a certain sense in the mercy of the court, seeking to explain why the court should not give the relief that one would ordinarily expect where there's a breach of a duty, which ordinarily, if the resources were available, would be to fulfil that duty? In other words, not the ordinary Wednesbury-type supervisory approach, but the onus being on Croydon to explain why the court should not make the usual order that would usually follow if there's a breach of duty.
Well, yes. The problem is it's not a level playing field. What might be regarded as a reasonable step in one area may not be regarded as a reasonable step in another. And so that's why the court should, at least to an extent, defer to the local authority, the position in the local authority. I mean, it could be the local authorities, in fact, got quite a lot of available stock. And that would be a factor that the court will take into account. So we say reasonableness has to be looked at against the backcloth of the circumstances in the borough. We do not say this...
Well, sorry, just on the point you just made, that it may be that the local authority has a lot of available stock, and the court would look at that.
Yeah.
I mean, at some level, isn't that the point that the Court of Appeal was making, that they couldn't tell there might be stock which was suitable and available, but in the Part 6 list, that if not treated as part of the Part 6 list, would be available to meet the needs of homeless people and to comply with the local authority's duty?
That would be open to court, but in this case it was foreclosed by the evidence, and I'll take lordship to the evidence in a moment. The evidence was no, there was no available stock, and crucially, Ms. Imam had been considered for everything that came in Part 6 or otherwise.
Was there not evidence that over the years, and of course this saga has covered many years, that accommodation suitable for somebody with disabilities equivalent to the claimants had been available in the Part 6 list, and others ahead of the claimant in the Part 6 list had been allocated to it? Yes.
Yes. And I think the point is that consideration should have been given, instead of allocating under the list, but to make make a letting outside of Part 6 through the non-secure route instead.
Yes.
And we say respectfully that's fundamentally wrong for the reasons set out in our case. Can I just go through those? What we're saying about the Court of Appeal's approach to this. We do make the point we do not want to put the court into a difficult position about this, but we do take the point that it wasn't a pleaded step. I think the position now is that the court has the agreed note. Something along these lines was raised in relation to the Equality Act ground, and mention to it was made in a reply. A reply is a it's not a recognised pleading, but the administrative court has a discretion to receive one, and also in a skeleton argument. But it wasn't, going back to the Dolan principle, discipline that I mentioned earlier about matters needed to be pleaded. So at the very least, I don't want to major on this point, because frankly, respectfully, Croydon has better points, we say, but That's why you don't see the Deputy Judge dealing with it in terms, and he would have done. This is a very respectfully thorough, conscientious, carefully reasoned, as Lord Justice Bean said in granting permission, judgment. So that's the first point. Secondly, we simply say, for a judge to concern themselves with whether a local authority should be granting secure tenancies or non-secure simply goes beyond the judicial function. And we pray in aid on that, in particular, Lord Neuberger's remarks in the Ahmed and Newham case at 1205. This was a case on Part 6, the lawfulness of Newham's allocation scheme, and at para 62...
I'm sorry, can you give the page?
1205.
Thank you very much.
And Lord will see this point also highlights how inapt it is for the courts to interfere with housing allocation schemes, saving clear and exceptional circumstances. This result follows from the striking imbalance between supply and demand. Further down, knowledge of the circumstances of applicants generally, long-term strategy considerations, expertise, political and social awareness, and local knowledge all have a part to play when it comes to formulating and implementing a housing allocation scheme. The court should be very slow indeed to second-guess the local authority. I've taken the court already to that Part 7 policy, which sets out the way that Croydon, a published policy, approaches Part 7 cases. That policy is made for the benefit of local people to whom Croydon is democratically accountable. And there's no challenge to that policy. Now, I invited your lordships just to note what Lady Hale said in the Nazema Meso case about if you can have a policy, that may be a better focus for a challenge. So we have the Part 7 policy. No challenge was made to that policy, and yet the Court of Appeal says you have failed to demonstrate that a reasonable step would be to do something which is outside the scope of your own policy. We say respectfully that's going too far. We also say that the step the Court of Appeal identified would be an irrational and administratively unworkable step in any event. What it requires is the local authority to grant, let's say the applicant, a non-secure tenancy. As your lordships have seen, the power to do that carries with it a power to subsequently convert it into a secure tenancy.
But, sorry, just on that, if you could subsequently convert it into a secure tenancy, that would be doing something which the policy in relation to the Part 6 allocations would govern, wouldn't it?
Yeah, that's an allocation.
So you couldn't, in fact, convert to a secure tenancy if that would cut across the Part 6 allocations policy.
But respectfully, Lord has my point. But sorry, but I'm putting it against you, if you like, because the fact that it would be unlawful to depart from the allocations policy shows, doesn't it, that all you could do at this stage would be to grant a non-secure tenancy. There wouldn't be a risk of that being converted into a secure tenancy later, unless that such conversion was going to be in compliance with the allocation. Lord, I don't... Sorry, forgive me.
Sorry, I'm asking you
I'm not
to tell me if I'm
disputing
wrong.
the legal root of this.
Right.
What I'm saying, I put this under the heading of irrational and administrative unworkability. What I'm saying, the submission is simply this. I don't think it's as high level as the legal analysis that the Lord's put forward. I simply say this. If they grant an applicant a non-secure tenancy, so that they can provide accommodation that would otherwise be in the Part 6 pool. That wouldn't be an allocation. It would come out, it'd be outside the terms of the allocation, but they could not subsequently exercise that power that we've seen in Para 4 of Schedule 1 of converting it, because the conversion would be an allocation. But the problem is, as soon as they've granted the non-secure tenancy, the applicant is adequately housed, so they'd lose all their housing, their priority. They would go down in the list. So the upshot of it would be that both the applicant and the local authority would be locked into a non-secure tenancy, and that's a bad thing. That's not sensible housing management. Non-secure tenancy.
You say that, but the council has a duty to provide suitable housing. I mean, it has a legal duty to do that. So if it has the capacity to remove a property from the Part 6 list, and the effect of that is to take it outside something which is governed by the allocations policy, which only applies to properties in the Part 6 list, it may be that that is a way in which the duty can be satisfied. And you say, well, that's not sensible, but if the council has a legal duty to do that and can comply with that duty in that way,
no, it doesn't.
Maybe sensibleness doesn't come in directly.
It doesn't have a legal duty to do that. This comes back to my submission about the broader nature of the duty. It's not a duty that trumps all others. I mean, this is the fundamental problem with this case. Whether the homeless applicant goes immediately to the top of the list. And we say that's not okay. That's not what Parliament intends. Yes,
when you say it goes to the top of the list, they're not going to the top of the list of the Part 6 list, because for the reasons we've just been debating, that they can't be granted a secure tenancy, because that would cut across the allocations policy in relation to the Part 6 list. It's true they've gone, in a certain sense, to the top of the list in that they physically get to go into a house that they need. But the council has a duty to provide them with a house which is suitable.
Yeah, Lord, I put it in the second way that your Lordship has formulated, perhaps rather crudely. The available pool of accommodation, they get first claim on the next available property. I mean, we simply say that this is a step too far. You've got a policy which deals with the way that the housing stock is allocated both under Part 6 and particularly under Part 7. There's no challenge to that policy, and it's not respectfully for the court to say you have to demonstrate why you have failed to take a property from the pool that would normally go to others and granted under a non-secure tenancy simply to get round the problem with allocation. And we say that that is an irrational step, and we say that that is an administratively unworkable step, and that we say that that is more than the main housing duty, properly understood, requires of a local housing authority. And we go back, this is why I took time to take your Lordships through the Din, Paul Hoffer, and in particular the O'Rourke cases to look at the wider social purpose.
But where do we get the point that it's inconsistent with the Part 7 policy from?
I'm sorry, Lord.
You made the submission, I think, which seems to be quite important to your argument, that this would have been inconsistent with the Council's Part 7 allocation.
Yes.
Where do we find the material that makes that good?
In the Part 7 policy, which I took the court to earlier this morning.
Well, I know you showed it to us, but at that point I didn't have the submission in mind, so it don't not solve
No, perhaps we could just go to that again then. It begins at uh, 415 of the appeal documents. And it's section 4, page 417, due to the high level of homeless demand within Croydon, normally a two-stage process, nightly accommodation then moved into longer TA supplied, offered to a private sector PRSO. 4.3, where there is more than one household requiring move on, stage accommodation will normally be offered to the homeless household with the earliest booking date. So on then 4.3.5 at 418, some temporary accommodation is specialist, for example, those with physical disabilities, units would be offered to those who meet the criteria for this type of accommodation. I mean, the submission is this, that in a nutshell, they have a policy for Part 7. It's non-statutory, but it's recommended by Lady Hale in the NMSO. It has an order of the way they deal with things. And that policy's not been challenged.
But where does the policy say that you can't use the Part 6 housing stock for allocate for this purpose? Because
this is a policy which deals with the way they meet their Part 7 duties.
But it doesn't preclude them using this terminology, raiding their Part 6 housing stock to make available properties which can then be used to fulfil this policy, which is the Part 7 policy, does it?
Can I, please, to answer my Lord's question, can I go to Mr. Beasley's evidence? Because we say in any event, this is our fourth point.
Before we move to the evidence, is there anything further you wanted to show us in the Part 7 policy which would preclude the Council from doing that?
Nothing else in the policy, no.
All right.
The fourth point we make on this ground, so we've made the points that it wasn't a pleaded matter before the judge. It's not.
There seems to be something called a Part 7 accommodation supply policy, which would tell where the accommodation comes from, but we don't have that.
No.
But it said it wasn't yet available when this was.
That wasn't in evidence, my Lord, no. And the last point we make on ground 2
were you going to take us to Mr. Beasley?
I'm sorry?
Were you going to take us to Mr. Beasley?
No, I wasn't, my Lord. No, I'm just summarising.
Right.
I'm just summarising the case, just so we don't lose sight of it, that we're putting forward on ground 2. And there are different strands to the case that we're putting forward. It starts off with the pleading point. I've made the point about the administrative workability. I've made the deference point about it's for the local authority to decide how they order their priorities, and no challenge to that. The final point we make on ground 2 is that even if we're wrong about all of that, it was there in the evidence. Why is Croydon not considering the use of its own stock for Part 7 purposes? Is there in the evidence in any event? And I'm about to take my Lord to the passage in particular, which is at page 445,
Thank you.
paragraph 86 of Mr. Beasley's witness statement. And it's under the subheading, the pool of available properties. The defendant has a substantial pool of council-owned properties. At the end of June 2020, total number of council-owned properties in the borough, 13,433. Even as considerable supply far outweighed by the demand for housing. Some of these council-owned properties are available to be allocated as temporary accommodation to homeless applicants under Part 7, and some are available to be allocated as permanent accommodation. So their council stock is used for both parts. The precise proportion of council-owned properties available as temporary or permanent varies depending upon the length of the waiting list for each type of accommodation, which are kept under constant review as the defendant reviews its allocation against its target's allocation policy and reallocates properties between temporary and permanent waiting lists and across the different priority bands throughout the year.
So just pausing there, that makes it sound as though the council it is capable of removing properties from the Part 6 list and putting it into Part 7 if...
What it does, it gets properties in and then it decides how it uses them. That's the evidence. However, we are actively considering the claimant for both temporary, that's Part 7, and permanent, Part 6, under Part 6 and 7 schemes. The claimant would have been considered for all council-owned properties that have become available since June 2015. Now, that was the evidence. That was unchallenged. So we say, in any event, this point, however it may have been put or not before the deputy judge, was dealt with on the evidence.
I'm so sorry to pick you up on this, but I mean, the penultimate sentence says that the precise proportion of council-owned properties available as temporary or permanent accommodation varies according to the length of waiting lists in each type of accommodation, which are kept under constant review as the defendant reviews its allocations against its target allocation policy and reallocates properties between temporary and permanent waiting lists and across the different priority bands. That sounds as though the council is capable of actively managing the property portfolios available for Part 6 and Part 7, yes, and of shifting properties between them if they think it's sensible.
Yes, exactly.
Sorry, you're saying yes, that is what happens.
That's what local authorities do. Well, that's the evidence there, my lord. I accept that's the evidence. But respectfully, the important part, particularly important part of that paragraph, is that the claimant would have been considered for all council-owned properties that have become available since 2015.
Yeah, but I think that the point that the Court of Appeal was making is that that may be too rigid, that if the council is treating as a fixed starting point, well, we've got a Part 6 list, and we know that the claimant isn't going to be high up the priority for that, so she's in effect never going to get suitable property if dependent on that. And within the Part 7 list, there isn't sufficient property, which means that they can allocate property suitable for her needs within Part 7. That's too rigid, and that maybe the council should be thinking of removing properties from the Part 6 list, which would then be available and suitable for the claimant's needs under Part 7, at least as a possibility.
Lord, accept that. The crisp answer to that, respectfully, is that's going too far in the Lord Neuberger sense. That's why I took the court to Lord Neuberger in paragraph 62 of the Ahmed case. That's the court engaging in allocative policy.
But that's the court, if I may say so. Ahmed was a case of the court reviewing the legality of a council's own decisions in relation to allocation policy, and where there was a challenge to what the court had done in setting its policy. And since that was a matter for the decision of the court, the usual judicial review standard applied, and with a great deal of deference to the decision of the local authority. But here we've reached a point where there's a breach of the relevant legal duty, and the question is whether the council can come forward with good reasons why a mandatory order should not be made.
Yes, well, the good reason here, my lord, is that the council, rather than to take a property out of the pool and to grant it on a non-secure tenancy, which is a very unsatisfactory way of providing accommodation, bearing in mind this is a very high-need household. And I've taken the court to that passage in the Code of Guidance which says within available resources, the local authority should try and get more settled accommodation for somebody who's more needy. That's an underlying problem in this case. It would be much better for Croydon to find a long-term solution for this family than a quick fix that would come within Part 7 and which would come to an end. That's what they've been trying to do. And they have considered her for every property that's come into the pool. Now, technically, I'm so sorry.
Which pool are we talking about?
When I say the pool, I'm saying generally to the council, before it goes in Part 6, Part 7.
They do it under different criteria, though, don't they? Because they allocate properties to Part 6 and properties to Part 7. And then they look at the claimant's position here by reference to the Part 6 criteria and policy and the Part 7 criteria and policy. So what Mr. Beasley says here is correct, but the authority is applying, and I'm not saying it's wrong to apply, the criteria of the two different policies.
Well,
in relation to the particular properties allocated to the two pools.
Yeah. And all, respectfully, the problem with this is it demonstrates the point. It sucks the court into reviewing the policy.
I can see what you're saying. Better, really, for the court to say, you owe a duty, you must perform it, get on. You decide how best to perform it, rather than trying to micromanage the way in which the authority does perform its duty.
Well, my Lord, again, respectfully, that's too simplistic. For the court simply to say it's a duty, we enforce it, simply fails to recognise the realities. I mean, the problem with that approach, the harder the press the local authority, the more difficult it will be for that authority to comply with a mandatory order, which is contempt if breached, with serious consequences. And that's simply wrong as a matter of principle. Inevitably, what authorities will have to do, if they haven't got the resources to comply with the court's order, what they will have to do is to take that claimant out of order and pile their such resources as they can get, to the detriment of others, into that one case. There have been a number of cases in the law reports where judges have said, if necessary, you must buy a property for this applicant. Enough is enough. The impact of requiring a local authority to go into the private market and purchasing a property for one applicant in financial terms has the same detrimental impact on the service generally as awarding damages, and therefore it runs contrary to the rationale of O'Rourke, which is why we put that case forward. This is an approach we say this firmly with respect. If this is right, it's an approach that favours the litigant. The person to come before the court gets the spoils. And it's simply contrary to any general principles of remedial discretion for the court to make an order that it knows will have a significant impact on third parties without considering those third parties. That, we say, is unusual and wrong in principle. So we simply say our case is that you should not exclude the possibility that the judge can have regard to the resources of the local authority and able to meet its responsibility and what it has available in the position of other applicants, whether they're other Part 7 applicants or Part 6 or whatever. Certainly if there are other Part 7 applicants owed a duty, the court cannot approach it with tunnel vision, excluding those. That's simply not the scheme that Parliament has put in place. So the court does not respectfully enforce the duty that the local authority must comply with. I mean, that, in a nutshell, is our case at 1 o'clock. Lord, I do have some concluding remarks.
Yes, well, you have 15 minutes after.
I have 15 minutes maximum, but if I can come under time, I please my Lord at least on that.
Very good. Thank you, Mr. Rutledge. We'll rise now. We'll sit again at 2 o'clock.